under success fee, which refers to the percentage set out in the agreement, A says the fact that if you lose, it reflects the following. A, the fact that if you lose, we will not earn anything beyond that portion of the advance fee which we've been able to retain. And then D, sub D, the fact that if you win, we will not be paid our basic charges until the end of the claim. So the effect of those provisions is that it covers the whole of the claim. And at this stage, obviously, the claim had not been issued, but not an appeal. The success fee is payable in the event of a win. And if we go to page 15, win is defined in the last paragraph on that page. You achieve a settlement or any other benefit arising out of the claim. Or if you do not achieve a settlement and you go on to issue proceedings, the court orders in your favour and orders your opponent to pay you costs. The reference on page 11 to the fact that if you win, we will not be paid in sub D, we will not be paid our basic charges until the end of the claim, suggests that the fee is payable at the end of the claim. So you need to have a win, and you need to be at the end of the claim to be able to be entitled to a fee. After the proceedings were commenced, there was a direction for a split trial on liability, and that was in fact made by Master Rees on the 14th of June 2011. That's reflected just for reference. I don't think it's disputed in a subsequent Court of Appeal judgment in the case. There was then a 12-day trial on liability before Mr. Justice Voss, as he then was, who handed down judgment on the 21st of December 2012 in favour of GEHC against Mr. Gray, and he adjourned all consequential matters to a further hearing. That further hearing took place on the 17th of January 2013, when the judge declared that Mr. Gray had acted in breach of fiduciary duty and that he was liable to account to GEHC in equity for all benefits received by him consequent on the breach. He ordered an accounting inquiry, and he ordered Mr. Gray to pay costs of the liability stage with an interim payment on account of costs of 1.2 million. So that was on the 17th of January 2013, but on the day that judgment was handed down, at which point no order had been made, Rosenblatt delivered an invoice on that day claiming a payment of the sum of £3.269 million. And if we go to tab 3 in the supplementary bundle, page 16, this is the invoice that was submitted, and if we go over the page, you can see that it calculates the sums on the basis of, I think what we're concerned with here is the first couple of entries, total time recorded, and uplift at 100%. So it was treating it as the CFA as having triggered the entitlement to basic charges and success fee at that date.
So it's on the basis of a win at that time?
Yes. That was erroneous, as Rosenblatt accepts, because at that point, first of all, no order had been made consequent on the liability judgment, and therefore no win for the purposes of CFA 2. It can further be said that on the, having regard to the term I just took you to in CFA 2, that the sum would not become payable until the proceedings had come to an end, which obviously they hadn't at that stage. The win, not entitlement to payment, but the win did not occur prior to 17th January 2013, when there was the consequentials order made by the court, including the orders for payment of costs and interim costs. The consequence of the bill of 21st December 12 not being issued at a time when the sum had fallen due is that it did not constitute a statute bill for the purposes of the running of time, effectively limitation to challenge the bill. And that's issue as to whether or not time had expired or not was what came to be called in the proceedings the scope issue, which was decided against my clients by Master James on the preliminary issues stage, and that part of the decision was upheld, though not necessarily for the same grounds, by Mr. Justice Trower in his judgment. So that bill effectively gets rolled up into the bills which were rendered at the end of the retainer. Just returning to the chronology, consistent with the understanding that CFA 2 had come to an end following the win before Mr. Justice Voss, as he then was, Rosenblatt proposed a new CFA to cover the accounts and inquiries stage, and this was CFA 3, dated the 6th of March 2013, which I'll come to in a moment. Just before I do, during the first stage of the appeal before Mr. Justice Marcus Smith in June of 2025, the judge quite rightly sought clarity as to the parties' respective positions on the interrelation between CFA 2 and CFA 3 in circumstances where, first of all, there was an overlap between the two agreements because CFA 2 covered the whole claim and CFA 3 covered, if you like, a subset of the claim, which was the accounts and inquiry stage only. And secondly, in circumstances where it was common ground that the result of the judgment of Mr. Justice Trower was a finding that CFA 2 had not been terminated by CFA 3. So we had CFA 2 in some form subsisting when CFA 3 comes to be entered into. The answer to the judge's questions had potential implications on the grounds of Rosenblatt's appeal to the judge on the merits of objection 1, because it fed into the analysis of what had been terminated and what performance was still required of Rosenblatt at the point of termination. Whilst the parties were considering the answer to the judge's question between the hearing of the abuse stage appeal and the merits appeal, we put forward a primary position and two alternative positions. If we're wrong on the primary, then there's this alternative or that alternative. I don't need to get into the detail of it. In response to the judge's questions. And the alternative positions gave rise to an application for permission to amend the grounds of appeal, which we would need to do if we were going to be advancing these alternative positions. In the event, in advance of the hearing of the merits appeal, the parties reached agreement in the terms of Rosenblatt's primary position. And that is why it is recorded, and if I can just take you to the judgment of Mr. Justice Marcus Smith on the merits appeal. So if we can go in CB volume 1 to page 184. 184. Yeah, 184, which you'll find at tab 19. And if we turn in that to page 188, first of all, perhaps just pick up paragraph 18. He says, in the third line, questions from me in seeking to understand the complex procedural history and interrelationship between CFA 1, 2 and 3 prompted a thought on the part of Rosenblatt's team that grounds appeal should be amended. The amendment makes the point that if an amendment had been sought at the time that the abuse hearing was about to be heard, it would have been refused. He then says in paragraph 20, in the event these proposed amendments are no longer moved, I need to consider them no further. The proposed draft amended appeal sought to deal with the case where CFA 2 had not been fully replaced by CFA 3. Parties submitted their agreed that CFA 2 had been completely replaced by CFA 3, and this was the basis on which the senior cost judge had proceeded in the decision. And then he says, in these circumstances, I make clear at the outset of oral argument, my decision on this appeal would be based on the common position that CFA 3 was the only relevant agreement. A slight but not material qualification on that, which we refer to in our skeleton on the merits appeal at paragraph 8, which is that in fact what was agreed was not that CFA 3 completely replaced CFA 2, but rather that CFA 2 was amended by CFA 3, that these two agreements constituted the retainer for the purposes of the conduct of the grey proceedings, but importantly with the effect that the payment terms were governed by the terms of CFA 3 rather than CFA 2, and that's what is obviously...
I had understood that this appeal was being argued on the basis that we were concerned only with CFA 3.
Yes, that's why I say it's a qualification but not material, because ultimately you are being asked to decide is effectively by reference to CFA 3, but I just wanted to just correct.
That explains how that comes about.
Exactly.
Right.
Now, after that slight digression, if I can take you to CFA 3 itself. So that is its second volume of the core bundle at tab 22. Starts at page 203. This is in different form, as will be readily apparent, to CFA 3. It's a bespoke agreement. And if we turn to page 205, we have the definition of the claim, client's claim against the opponent in relation to accounts and inquiries and other relief ordered. There's a definition of Rosenblatt's fees, which you can see a bit below that. And then at the bottom of the page, success fee, the percentage of Rosenblatt's fees at the normal rates, which are added to the client's bill if the client wins the claim. And then over the page, what does it mean by winning the claim? It's where the client's claim is finally decided in the client's favour, whether as a result of the court making an order for damages in the client's favour or the opponent agreeing to damages, irrespective of whether, of course, order is made in favour of the client. And finally, in that context, means one of the following: A, the opponent's not allowed to appeal against the court decision; B, he's not appealed in time; or C, he's lost any appeal. And then further down under fees and disbursements, 4.2, Rosenblatt's fees are calculated by reference to hourly rates, and those are set out on the next page. And on the next page we have 4.3, the client shall pay the advance fee, which is a sum of £300,000 upon completion of this agreement, retain whether the claimant is successful or not. Credit will be given for the advance fees in the event that further fees are payable. And then what happens if the client wins at 5.1, then he's liable for the fees at normal rates together with disbursements and the success fee. And then over the page at 6, if the client loses the claim, Rosenblatt will retain the advance fee. Client will be liable for any outstanding disbursements, will not be liable for the success fee. And the success fee, we can see at 7.1 is set at 100%. And then particular relevance when we get to the merits appeal, we go to page 210. Clause 13.1, the client's responsibilities include giving Rosenblatt full, honest and timely instructions. You see what else is said in that sub-clause. And then Rosenblatt's responsibilities set out in 13.2. And then we have the provision for termination, which, as I say, will be the focus of much discussion on the merits appeal. So 14.1 gives the client a right to terminate the agreement at any time. In that event, if he doesn't continue with the claim, he's got to pay Rosenblatt's fees at the normal rates for the work done. If he does continue with the claim and wins, then he will also have to pay the success fee for that work. So on a client termination, lawful termination under the contract, that's the consequence. And then there's provisions in relation to Rosenblatt ending the agreement. So 14.2, Rosenblatt can end the agreement if the client rejects Rosenblatt's advice to accept a reasonable offer. In those circumstances, the client must pay Rosenblatt's fees for the work done to termination date and disbursements. And if he continues with the claim and wins, he'll also have to pay the success fee. So to that extent, mirroring 14.1. Then we have 14.3. Rosenblatt can end this agreement if the client does not meet its responsibilities. Client's responsibilities are set out at 13.1, as we've seen. If this happens, the client will have to pay Rosenblatt's fees for the work done to the termination date and disbursements. So in the event that a contractual termination is carried out pursuant to 14.3, that is, there is provision for precisely what Rosenblatt will be entitled to. You'll see there it doesn't include anything in relation to subsequent success fees.
14.1. What happens if they continue and lose?
If they continue and lose, then there will be no success fee payable, but under 14.1, the client's still paying Rosenblatt's fees.
Where does it say that?
Because it says the client can end the agreement. Oh, sorry, you're saying if he continues with the claim and loses. I'm sorry.
We've got if the client does
Yeah.
not continue the claim. We've got if the client continues the claim and wins.
Yes, I'm
What
sorry.
happens if
I
the
beg your
client
pardon. I
continues
misunderstood
the
you.
claim and loses.
Yes, obviously it doesn't spell it out, but I think it must be implicit from this that they get nothing in those circumstances. Because there's been no event of success, and the client's liable in the event that they win. And that would be my reading on it. The only alternative to that would be they'd be entitled to their charges whether or not they continue with the claim. So they'd be obliged to pay Rosenblatt's charges whether or not they continue with the claim, and 14.1 does not say that.
The reason why I ask is it occurs to me it might be material to your arguments on the merits. But we'll come to that.
We'll come to that. We then have 14.3, as I say, the provision which I've just taken you through, and then 14.4, Rosenblatt can end this agreement if it believes the client no longer has a reasonable prospect of success. In that event, the client will only have to pay Rosenblatt's fees and disbursements. In fact, that may be relevant to 14.1, so let me just reflect on that further in case I want to revise what I've just said to my lord on that. Because that's a...
If the client sticks with Rosenblatt and pursues the action to the bitter end and loses,
yes,
then apart from the advance fee, the client pays nothing.
Correct.
So going back to 14.1, it would be odd if the client changes solicitor and still loses, that it would have to pay Rosenblatt's anything.
Yes.
The whole basis of the agreement was you only pay if you win.
Yes, but you only pay if you win circumstances where Rosenblatt is acting as your solicitor. The agreement was, before you get to the termination provision, the agreement is all concerned with Rosenblatt acting as the solicitor on the case, and the case going to the end, and the results dictate what entitlements arise for payment. So this is we then have these termination provisions which give the clients, leave aside 14.3 at the moment, gives first of all the client the right to terminate without breach, just simply a contractual right of termination. And then gives Rosenblatt the right to terminate under 14.2 and 14.4 in circumstances where there's no requirement that there be found to be a breach of contract. And then we have 14.3, which is a contractual right of termination on breach of the client of its responsibilities, without any requirement that those be breaches that go to the root of the contract or repudiatory. It could be a termination falling short of any repudiatory breach. Indeed, one of the points that Mr. Justice Trow had to deal with in the appeal against the judgment of Master James was the question of whether, in making her findings in relation to the fact that the solicitor would have had a right of termination under 14.3, she was accepting that the solicitors, or finding that the solicitors would also have been entitled to terminate for repudiatory breach, and he was saying that that doesn't follow, and then went on to consider whether or not there was a repudiatory breach. I'll come back to revisit 14.1. Let me have a think about that further. But what we say when we come to the merits appeal is the underlying basis on which the services were being provided was that we wouldn't be unlawfully prevented from the opportunity of earning our fee, completing our retainer and then earning our fee. And 14.1 is obviously not a case of unlawful prevention by the client. It's something that's lawful. As I say, we'll come back to the agreement a little later on the merits appeal. If I just continue with the chronology, subsequent to entry into that agreement, we have on the 24th of February 2015, Master Leonard assessing the costs that had been ordered by Mr. Justice Voss, and they were assessed at just over 2.3 million and were paid in October 2015. In July 2015, following a 21-day trial on the hearing of the account by my lady, Mrs. Justice Asplin, as she then was, judgment was given ordering Mr. Gray to account for certain sums which were assessed in the order of £3.6 million, with a further hearing to take place on the value of Mr. Gray's interests in certain business assets. That hearing eventually took place before Mr. Justice Arnold, as he then was, over 6 days, 5 or 6 days in 2019, and he assessed the value of that interest at nil. Now, in late 2015, running into early 2016, there was a dispute between GEHC and Rosenblatt as to whether an agreement had been reached between them concerning whether Rosenblatt was entitled to retain a sum of 1.3 million received from Mr. Gray to meet future disbursements for which GEHC was liable under the terms of CFA 3. Despite this agreement, GEHC continued with the retainer. And then on the 24th of February 2016, Rosenblatt terminated CFA 3 on the grounds of GEHC's repudiatory breach. And the letter of 24th February 16 is to be found in the supplemental bundle at tab 4. It starts at page 18. And it's addressed to Eversheds, acting for GHC in this line of correspondence, and it made reference to an August 2015 agreement, and it was that agreement, I don't think I need to get into the detail, which and subsequent steps taken in relation to it, which had become the subject of dispute. If I could pick up the letter, I think the most important parts, which are certainly referenced in the judgments, are starts at page 21. And the two elements of dispute from the solicitor's point of view concerned one, the ability of and willingness of GEHC to discharge disbursements, and in particular GEHC saying that it should be Rosenblatt who should be discharging disbursement. And secondly, that they were wanting to bring on, had brought on Bird and Bird to also act in the case, and were expecting Rosenblatt to carry out the instructions of Bird and Bird. And at paragraph 19, there's reference to that last point, and evincing an intention to be no longer bound by clause 13.1, which obliges GHC not to act in an unreasonable, ask Rosenblatt to act in an unreasonable way, and then there are the points made at A and B, and then over the page, in conclusion, notwithstanding GHC's avowed expectation that Rosenblatt should continue to act in accordance with the CFA, GHC has now repudiated the CFA by, and then there are the three matters which are relied upon, which you can see there at A, B and C. And then below that, having offered GHC an opportunity to withdraw its allegations, and requested that GHC provide us with the requisite monies on account to cover disbursements. Having the offer refused, been expressly instructed to comply with the instructions, Bird and Bird no longer have any option other than accept GHC's repudiatory breach. CFA is therefore terminated with immediate effect, and we're entitled to damages. Damages in this context are immediate payment of our base fees, the payment of the success fee in the event that GHC is successful, and damages in respect of lost fees. And then they'll say they'll need to come off the record. And the invoice which follows that letter is at the next tab, tab 5, page 23.
Yeah.
And in the cost assessment proceedings, to which I'll turn shortly, the GHC were arguing that the termination by my clients of the retainer was unlawful, and that was overturned on appeal by Mr. Justice Trower. I don't think I need to take you to that at this moment, it's just further detail. Following the termination of the retainer, GEHC commenced the Part 8 claim seeking assessment pursuant to Section 70 of the Solicitors Act. The bills rendered by Rosenblatt, principally for not only the 2012 and the 2016 bills which I've taken it to. As at the date of termination of the retainer, it had only been part performed as the action was still going on in the Gray proceedings. After the hearing in front of Mr. Justice Arnold's, he then was, where he valued the assets at nil in 2019, Mr. Gray appealed the orders of the order of Mrs. Justice Asplin to the Court of Appeal, and that appeal was dismissed on the 9th of December 2020, following a 6-day appeal before this court. So summarising the effect of all those events in terms of CFA 3, first of all, as at termination in 2016, there had neither been a win nor the end of the claim, because a win depended on a result which would need to have been achieved not just at first instance, but following any appeal. Secondly, in practice by that time, GEHC had achieved considerable success by the time of termination because of the orders that had been made by Mr. Justice Voss and Mrs. Justice Asplin. And if those orders were not overturned on appeal, as ended up being the case, they would be a win for the purposes of CFA 3. And thirdly, if the retainer had still been in place up to the conclusion of the first instance proceedings, a win would have occurred upon the disposal of the appeal, giving rise to entitlement of a success fee.
So that's in December 2020.
Yes. I want to move on from there to the second part of my submissions, which is on abuse. First of all, by way of summary of our position, I want to make the following submissions. Before getting into the detailed facts which form the basis of the of this appeal, first of all, just draw your attention in our skeleton at paragraphs 4 to 8. So this is at CB/3 if you have it, unless you have it separately, page 19. Just sets in paragraphs 4 to 8 just set out a bare outline, which I'm now going to try and fill in of the basic facts relating to this part of the appeal. That led to paragraph 8, the strikeout application before the senior cost judge, which failed, and it failed on essentially on the basis that whilst the judge considered that the GHC could and should have raised objection 1 earlier, there was no abuse of process because no decision had been made in respect of objection 1. We've summarised that in our skeleton at start at paragraph 28 and following, and picking up at 31 sub A. point I've just made, that we said objection one, whilst the subject to judicial comment had not been the subject of decision, he said the result of the preliminary issues proceedings would have been the same if it had been raised earlier. And objection one, raising it late did not constitute unjust harassment.
Could I ask you a question?
Of course.
You say in paragraph 4 of your skeleton that Master James directed the hearing of 2 preliminary issues, and indeed she did. And then you go on to say, as recorded by Cost Judge Gordon Saker, these preliminary issues were intended to deal with liability.
Yes.
Where does Master James say that?
Just give me a moment.
Apart from formulating the 2 issues which she ordered to be tried as preliminary issues, where does she say that that's supposed to encompass everything to do with liability?
Just give me a moment. Now, so if we go to tab 29 of, sorry, tab 28 of core bundle 2, which is his judgment. Sorry, that's, just give me a moment, that's the wrong one.
28 is Judge Gordon Saker.
Sorry, it's the right judgment, yeah.
Master James's order is in the supplemental bundle, tab 10.
Yes, we'll come back to that in a moment when I take you through that in detail. Yeah, so if I look at the senior cost judge's judgment, which is what I've referred to in paragraph 4 of the skeleton.
I accept that that's what the senior cost judge says.
Oh, I see.
But that's his take on the order that Master James made. I'm
Yes.
asking you whether Master James said that, and if so, where?
No, she didn't. She didn't give a judgment, and that's why I need to take you through in detail the circumstances leading to the making of that order, so that one can understand what was being put before the court. What we say is clear from what was being put before the court, and I'm going to come to this in just a moment, is that what was being presented to the court were the issues on liability, which had been identified as between the parties. And it was being proposed that those should be determined first. The GHC position was that should all be determined in Part 7 proceedings in the Chancery Division, whilst the position of GHC was that it should be determined in the senior cost jurisdiction, which is what eventually the master did. And the preliminary issues which were identified were the issues on liability. The preliminary issues that were identified within the order were the very issues on liability that have been identified as between the parties. So we say that
when you take us to it, will you show us where it is recorded as being agreed between the parties?
so
I may not have read it. I've read the skeletons,
right.
and at the moment, until you show me something different, I don't think that appears in the skeletons.
So what one, okay, I'm going to jump ahead of myself a little bit, but I will come to this when I go through those documents in detail. What we say is that when you look at the witness statement, particularly Mr. Nimmo, he identifies what are the issues. There is then a skeleton that comes in from GHC in advance of the June hearing, where they take the position that there's very little between the parties. And then there is my client's skeleton, which reiterates the position on the issues of liability. So there was no, if one takes the documents that were put before the cost judge, there was no disagreement that one can see. I'm putting it in those terms. First of all, there was no disagreement that these were the issues on liability. No other issues that as to why there was no liability were being put before the master. There was then a hearing on that basis. So whether in my submission, it's clear that that can be regarded as common ground. Certainly there was no other issue or no,
You say it was common ground, that no other liability issues would ever be raised, or that these were the liability issues that were in play at the moment?
that these were the liability issues that had been identified. And a preliminary issues hearing ordered on that basis. And the whole justification of this approach was that it made sense to determine the issues of liability before embarking on an assessment, because the assessment might become completely unnecessary if liability
That's still
was
the
found.
case, isn't it? If objection 1 is allowed to be taken, it's still being decided before the line by line assessment.
But many years later,
Well, that may be, but it's still within that overall framework of deciding all questions of liability before you go through a line by line assessment.
but if objection 1 was going to be raised at all, should have been raised in the context of preliminary issues that had been ordered, particularly when one actually looks at the pleading of those preliminary issues.
Pleadings change. Everybody knows that pleadings can change in the course of a case that hasn't yet concluded. People apply to amend their pleadings.
Yes. But
Sometimes they even try and take new points on appeal.
yes. Okay, so I am slightly jumping ahead. Maybe I can address those points. I have those points obviously in mind, and let me address them when I come to the relevant facts, in particular the matters leading to the June order and the pleading which followed the June order. Because one of the points we rely heavily on is that the key issue for determination on the preliminary issues was whether there was no liability because of wrongful termination. So there was a whole, and it was then pleaded that if there was lawful termination, then we were limited to 14.3. Objection 1 is saying, effectively, well, none of that actually matters. Because even if, as the solicitors say, they lawfully terminated, there's still no liability. So this isn't a matter of some completely separate new defence of liability. This is a defence going to liability which is intricately connected, very closely connected with what was being advanced in front of the court on the preliminary issues. So that even if I don't persuade you that when the preliminary issues order was made, it was intended to deal with the liability issues, with liability by reference to the liability issues that had been identified. It nevertheless is the position that this is an objection, a defence on liability, which if it was to be raised at all, should have been raised in the context of what was a preliminary issues hearing that was focused on termination and its impact as a defence to the claim for payment. I was still on the point of dealing with our case in a nutshell. As the court will have seen from reading the judgment of Mr. Justice Marcus Smith, he held that on the facts stated by the senior cost judge in his decision, that the raising of objection 1 was an abuse of process, and that the reason given by the senior cost judge finding it wasn't an abuse of process, namely that there hadn't been a determination, was not a good one. The judge nevertheless, in the light of the respondent's notice before him, found there was no abuse and he found that the June 2016 order represented a major procedural order on the part of Master James, and that the court expects their orders to be obeyed, and it would have been improper for Global to shoehorn or attempt to shoehorn issues into the preliminary issues ordered by the court. And as a consequence, there was nothing in Global's conduct to criticise, and therefore no abuse of process. If I could just take you, for purposes of putting my case on this in a nutshell, to the judgment at Core Bundle 1 tab 8, and pick it up at paragraph 25, which is at page 93.
Sorry, which?
Paragraph 24. So, paragraph 24, he says the primary point raised by GHC was the decision could be upheld on the other grounds. Then he sets out what that is, and then says this clearly is a very important point, and that if objection 1 had been raised consistently with due process, that's a very material fact. And then in paragraph 25, where he says the decision of the senior cost judge in a passage that had been cited earlier hints at these facts, he then examines the procedural history, and over the page, having noted that the usual practice of determining liability issues before any detailed assessment, he says in sub 3, by an order dated 16th June made without reference to a hearing for the parties, Master James made the following order, and then he sets out the order, and then at sub 4, having set out the order, and the order, we say, identified the defences that on liability that had been raised before the master, he then says that A, that the court disregarded Rosenblatt's suggestion made in accordance with the court's usual practice, dealing with all questions of liability first, and staying any question of detailed assessment until after these had been determined. But in fact, what Rosenblatt was suggesting was that the matter be transferred, as we'll see, to Part 7 proceedings, and that there would then be a preliminary issues heard there. And then importantly, at paragraph B, he says, instead, the court directed the hearing of only 2 preliminary issues as to liability. In doing so, the court appears to have considered that these were the only 2 possible issues going to liability. If that was the court's thinking, it was mistaken, for objection 1 was not identified. Well, the court was identifying the issues which I submit were identified before it as the issues on liability. So it's hardly surprising that objection 1 was not identified, and indeed it wasn't identified as a ground of objection until after Mr. Justice Trower's judgment on the hearing of the appeal.
When do you say was the cut-off point for the raising of objection 1? We know that the preliminary issues were directed on the 16th of June 2016.
Yes.
And we know that the hearing took place, I think, in 2018, dealing with those preliminary issues. It took 7 days, actually, including some dates in 2019.
Yes.
When was the cut-off date for raising objection 1?
Well, it should have, at the very, very latest, have been raised in sufficient time that it could be dealt with at the preliminary issues hearing. As to what that date would be would depend on how much time it would take to, in advance of that hearing, to take that point on board.
So when in 2017, the Global tried to enlarge the scope of the preliminary issues and the master refused, that we would not say was an abuse, presumably.
It was not an abuse on the part of
Global.
No. No, it was open to Global to put forward, and this is one of the criticisms we make of the judgment of the judge, because he says at paragraph 26 that the court expects their orders to be obeyed, and it would have been improper to shoehorn or attempt to shoehorn additional issues into what was expressly a preliminary issue hearing. I'm going to come to the March 17th judgment after I've taken you through the documents relating to 2016 and the pleading, which was before the court, both as at the outcome of that hearing in March 2017 on amendment, and then before the court.
Just that when you look at what the master decided in the 2017 judgment, it doesn't seem, if I may say so, consistent with the idea that all issues of liability, going to liability, should be tried at the same time, because Global Energy tried to enlarge the issues relating to liability, and the master in effect said, no, I've ordered these preliminary issues, that's what's going to go ahead. She doesn't say, well, that's it, you can't raise anything else, ever.
I mean, all we have in the bundles is the judgment, and the application was made at a time when the preliminary issues hearing had been set down for a number of days, I believe for October of that year. And the master is trying to regulate what can be heard at that hearing.
Right.
I understand that. It doesn't take away from the fact that really two things. One, that when she made the order in 2016, this was on the basis that there was an intention to deal with liability.
Well, the two issues, those issues had been identified.
Yes, and no other issue.
You accept it's not one shot and you're out.
No.
You can say, well, hang on, I thought of another issue that needs to be tried.
Yes, and that could be, and one would expect that if there was another issue raised, another issue to be raised on liability, that would be raised with the court before the hearing of the preliminary issues.
You also accept on your answers that if objection 1 had been raised at any time up until such time that it became impossible for it to be heard in the preliminary issues hearing, that would not be an abuse. And furthermore, the court could have said, no, I'm not going to include it in this hearing, in which case, presumably, there would be no objection to objection 1 being brought back in after the preliminary issues hearing.
No, if they tried to raise it and the court had refused.
So on that basis, the only foundation stone for your abuse argument was that they didn't, not consequences, but that they didn't try to raise it before the preliminary issues hearing.
Well, we say that they should have raised it. They should have raised, both they could and should have raised it, because and this is an issue, a ground of defence, which I come back to the point, which I'll make good when I take you to the pleadings, was intimately connected with the grounds that were being advanced before the court for decision on the preliminary issues hearing. This isn't some point about, as was sought to be raised, it appears, in the March 17 amendments concerned with particular aspects of misconduct to deal with not paying council's fees. This was very closely tied to the defence on liability relating to termination of the agreement. I mean, in short, it was being said that the termination of the agreement at a very high level, the termination of the agreement had the consequence that no sum was due. That's the nub of what the defence was. And indeed, they then went on to say, but if it was being lawfully terminated, then they should be limited to the amounts under 14.3. What they didn't say, this isn't some completely new line of argument requiring extensive pleading and evidence. It's effectively a legal point, which is to say that on the terms of the agreement, whether or not there was a lawful termination, there is no entitlement to payment. I mean, even if the position is that the preliminary issue wasn't designed to deal with all issues of liability, and in my submission that was the thinking when the order was made in 2016, nevertheless is the position that this particular line of defence could and should have been raised then, and then it would have been dealt with. It would have been dealt with. It's inconceivable that it wouldn't have been dealt with at the preliminary issues hearing.
I'm just thinking of the practice in this court. I mean, we're as you can imagine, we're used to people trying to take new points.
Yes.
And quite often, if the point is, as you described this point, a purely legal point, and it wouldn't have necessitated the calling of any additional evidence below, we allow the point to be taken on appeal. We don't say, well, you could and should have raised it below and that's it, it's an abuse. We allow the point to be taken. So what's wrong with the point being taken? Well, if it wouldn't have affected the preliminary issues hearing, it may be that the cost of the evidence of the preliminary issues hearing wouldn't have been needed if that point had been raised, in which case that can be compensated for the costs.
Well, because first of all, the point's not being taken until many years later. Secondly, the shape of the preliminary issues hearing might have been very different, because logically, if the position is that objection 1 is correct, the court doesn't need to get into questions, the other questions which have been raised as to whether or not there was unlawful termination of the agreement or its consequences, which is the subject of very extensive pleadings in just in the particulars of claim. In my submission, what one's looking at is whether the particular objection could and should have been raised at the preliminary issues stage. That's, in my submission, the key question.
If those, I mean, obviously it could have been raised, there's no question about that. Assume for the sake of argument that it should have been raised. I'm not entirely sure what should means, but let's suppose that it should have been raised. Is that the end of the argument on abuse?
No, it's not a simple tick box exercise, if you like. It's as we've been told, it's a assessment based on all the facts. having regard to all the circumstances. I'll remind the court of the, very briefly, because I'm sure you're aware of it, of the authorities.
Johnson and Gore.
It's referred to in orgy, so I'll just take you to orgy in a moment in relation to that. But the suggestion that is made by the judge that just sticking, we got slightly distracted from the judgment, just sticking with the judgment where he says in page 94 at sub C that having said the court should have obliged the parties to set out their contentions on liabilities in pleadings, he says, as it was, the court gave case management directions blind, directing preliminary issues when it was unknown what the issues between the parties actually were. And that's just simply not correct. It wasn't given blind. It was given after written evidence and submissions and following a hearing between at which the parties were represented and made submissions to the court, as to which we don't have, unfortunately, any record of precisely what submissions were made. But it's clear that this wasn't something made blind, and she's identified the very issues which were identified in the material before her. So we submit that the judge was wrong with due respect to him in making that finding, and indeed this rather infects the approach he took, which was essentially that, in my submission, that he was regarding the master as having gone on a frolic of her own, and that wasn't the case. And it's unfair to criticise her for making an order in respect to these preliminary issues in circumstances where it was done not off her own back, but in the light of the submissions that have been made between the parties. And of course, it was open to the parties, if they disagreed with that preliminary issues order, to take steps to challenge it. But no one did. Everyone proceeded along those lines, and therefore to then go on to say,
It did, because there was the further issues which arose in 2017 and
Yes.
the further decision.
but that wasn't a challenge to the order. It
Was
was
trying to add in,
Yes.
for the purposes of the preliminary hearing.
to add a particular point or points,
Mm-hmm.
which we'll come to, which you may have the impression, because these were points that were concerned with misconduct, that unenforceability on the grounds of misconduct was not in fact part of the matters that were being determined on the preliminary issues stage. But when we come to the pleading, you'll see that that's not correct. And in addition to the issues as to validity, enforceability of the contract, of the retainer by reference to Section 58 of the Courts and Legal Services Act, and in addition to the question of unlawful termination and its consequences, there was also four square before the master a case advanced at some length in relation to the agreement being unenforceable, and therefore complete defence on liability because of the misconduct of the solicitors. Essentially, as that was explained on the appeal of the master's decision before Mr. Justice Trow, it was an illegality argument, an argument that that misconduct, breaches of the solicitor's code of practice, amounted to unlawful conduct which would prevent enforcement of the agreement. The master did not make a decision on that because she made a decision that the contract wasn't enforceable anyway, but that was relied on as a respondent's notice before Mr. Justice Trow. So if you get the impression that in March 2017 she was kicking into touch any case based on solicitor's misconduct, that would be, in my submission, a false impression. So, in our submission, the judge's findings in relation to what the Master James did, her frolic of her own, infected everything else that the judge then found in relation to why there was no abuse, and essentially saying his finding that there was no fault on the part of GHC in the late raising objection 1. It's all because the master made, to quote him, a major procedural error acting of its own motion, which is obviously the headline point at subparagraph 4 on page 94 of the judgment. And in the circumstances of this case, it is our headline submission that objection 1 is very much an objection, if it was going to be raised at all, should have been raised at the time of the at the preliminary issues stage of this case, and it never was. If I can, after that rather lengthy introduction, as it so happens, go on to deal with the factual background. We've got the part 8 claim form, first of all. Just take you to that briefly. It's at Core Bundle 2, tab 31. This was the
index says this is 2016, but it's not dated.
it's
31st of March. In the chronology,
Yes.
31st of March. In the chronology, 31st of March.
yes, I'm told in the chronology we can check it. It's the 31st of March. The
31st
The
of March
index.
2016.
yes, the index gives it as 1st of April 16. So you can see that it details a claim dispute to which Part A procedure applies. In section 70, the court's inherent jurisdiction, then the following orders are applied for, and then there's an order for detailed assessment, and then further orders that are set out on the following page. Now that was either accompanied by or followed shortly by a witness statement on behalf of GHC of Mr. David Flack, dated the 1st of April 2016. That is in tab 6 of the supplemental bundle, starting at page 25. And in paragraph 4 on page 26, it's providing some purpose statement, provides some background to the application, overview of its position in relation to the invoices rendered, and then there was an application which this was evidence in support for an interim order for payment back. And at 5, he says, I do not propose to set out in detail GHC's position with regards to various invoices, given the court's yet had the opportunity to consider GHC's application and provide directions to conduct of the assessment. Then paragraph 12 on page 27.
Yep.
He refers to, it's the start of a section where he refers to the various CFAs, and then if we can skip to paragraph 25, page 30. There's a reference to this August 2015 agreement, which was the start of the what became a dispute between the parties, and he describes that dispute running through to paragraph 28 on the next page, and then it exhibits the correspondence. And then if I can pick it up at page 32, paragraph 32, it's their contention that the agreements are unenforceable, no sums are due. GEHC will set out in detail its arguments to why this is the case in due course, but in summary, its position that they're each variously in breach of section 58, as well as the relevant conditional fee agreement orders. So this is unenforceability for failure to comply with the Courts and Legal Services Act. And then he explains what those breaches are. And then he says, further, even in the event that any of the CFAs are found to be enforceable, they will contend there are various issues with them, and the invoices purported to have been raised pursuant to them, which would mean, for example, they were not entitled to raise such invoice, or such invoices are incorrect. And then he refers there to the points that we see in paragraphs 33.1 to 33.4. So these are particular challenges made to particular invoices.
Those are examples, aren't they? Including but not limited to, he says. He's not saying these are the only challenges we're ever going to make.
But these are
the ones that have been identified.
They're the ones that have been identified, and what's being referred to here are particular elements of invoices, rather than there's an absolute zero due for these reasons. He's referred to the unenforceability, and then, if you like, their particular matters or items.
He's saying two things, isn't he? He's saying Rosenblatt were not entitled to raise such invoices. That's one option. Or the invoices are incorrect. And then he says that he supports those alternative contentions by saying including because but not limited to, and then he identifies 4 separate points.
Yes. Yes, and he's referring to inclusion of success fees and various solicitor conduct points rising out in relation to the CFA. And then we have the witness statement of Mr. Nimmo on behalf of GEHC, which is at the next tab. And GEHC was seeking a stay of proceedings in favour of, or transfer of proceedings.
Did you say he's a partner of GEHC? He's partner of Rosenblatt, isn't he?
Sorry, did I say GEHC? I should have said Rosenblatt.
I heard you say that, but you may
Then I misspoke.
Yeah.
Thank you for
But
picking me
but
up.
he's
It's Rosenblatt, I beg your pardon. And if I can pick up his statement, firstly at paragraphs 5 and 6, which is at page 41. He refers there to, in paragraph 5, to the dispute that occurred in early 2016 between Rosenblatt and GEHC, and the allegation, you can see before we get to subs 1 to 3, that GEHC acted in repudiatory breach. Then at 6, GHC disputes the facts leading up to repudiation and disputes that it's acted in a repudiation of the standard terms. And then if we go on to page 42, under the heading the claim, which starts under paragraph 11, and then turn over the next page, it says in paragraph 13, for Mr. Flack's witness statement at paragraph 32, the GHC does not in fact merely seek a conventional solicitor-client assessment, rather it wishes to contend that each of the CFAs under which Rosenblatt have acted is unenforceable. Rather curiously, Mr. Flack has not set out his client's case in that respect, but said he will do so in the course of his detailed assessment,
And that gets
in
picked
due
up,
course in this assessment.
but that gets picked up in the skeleton, doesn't it? The fact they haven't done so.
Sorry, could you say that again?
That observation that he hasn't, he says he'll do so in due course of the assessment, but does not do so, is a point that is taken in Rosenblatt's skeleton.
Yes. Yes, I think that's correct. That's absolutely correct. We'll see that because we're going to get to the skeleton in a minute. And then 14, Rosenblatt accepts the applications for the assessment have been brought within the time limits. However, then 3 lines down, what is sought here is quite different. Before the court proceeds to any form of item-by-item assessment, 2 major issues will need to be determined. So he's identifying the 2 major issues before you get to any form of item-by-item assessment. The validity of CFA 3 and determination of whether GHC has acted in repudiatory breach of the CFA. I'll deal with the evidence required for those issues below. And then at 15, he deals with 2012 bills. And then if we turn over the page, at 19, it says that GHC also wants to establish that CFA 1 and 2 are both unenforceable. And he says, I'll deal with that in the context of the claim that CFA 3 is invalid below. And then at 20, dealing with the February 16 bill, I accept that GHC is entitled to detailed assessment. There's, however, no point in detailed assessment until such issues of principle have been determined as regards the validity of the CFAs and the termination of the retainer. And then at 22 at the bottom of the page, it deals with if CFA wish to dispute the effect of the advance fee and to argue CFA 3 is unenforceable, then this should be dealt with as preliminary issues before the court expends time and substantial costs in seeking a determination as to whether or not base costs are reasonable. And then at 24, if the court determines CFA 3 is enforceable, then the court will need to determine as a second preliminary issue whether it's acted in repudiatory breach. And it says the proper determination of that issue will require witness evidence. And then that leads on to
So I've
saying,
slightly lost track of the chronology. This witness statement and the one of Mr. Flack, this one is dated June 2016.
yes,
So this arises
before the preliminary issues
the
hearing.
preliminary issues
Yes.
hearing, but after the preliminary issues order.
Sorry, no. The chronology is Flack is 1st of April. This NIMO statement is the 10th of June. We'll then see 2 skeleton arguments.
Yes, but these were all
Also, sorry, this is 8th of June. We'll then have a skeleton argument of the GEHC of the 10th of June, a skeleton argument of Rosenblatt of the 14th of June, all prior to the hearing in front of Master James, and then the preliminary issues order.
So these were the materials that she had.
Correct.
Okay, sorry.
So I should have made that clear. I apologise.
No.
So yes, and then we have at paragraph 28 on page 46. that there's substantial issues of fact, and that essentially proposing that the preliminary issues should proceed before the High Court judge. And that's what, on the back of those preliminary issues that are identified, that is what the Rosenblatts are seeking. We've then got the skeleton arguments that were before the court at the hearing on the 14th of on the 16th of June, or prior to the 16th of June. I'm not sure if the hearing was actually on the 16th. It may have been the 15th.
I think it was. I think it was.
It was
I think so.
15th.
Yeah, the 15th.
15th of June. So the two skeleton arguments, we, in order of time, we first of all got the solicitor's skeleton argument. That's at tab 8. So paragraph 1, number of difficult and complex factual legal issues need to be subject to trial before any detailed assessment. This is particularly because the claimant's primary argument is that the claimant is not liable to pay any costs. It must follow, if the claimant is right on the issues of liability, which must be determined on the basis of pleadings, disclosure and witness statements, there will be no need for any detailed assessment. And at paragraph 2 over the page, that the court therefore invited to order a stay of the detailed assessment proceedings and transfer to the Chancery Division for determination of dispute between the parties as to liability at a trial before a High Court judge. And then there's reference there made to Mr. Flack's witness statement, and in that context that I think we get to the passage that my Lord Justice Stuart-Smith had in mind, which is paragraph 7, that it includes further unpleaded arguments. There's first of all a reference to unpleaded arguments in 5, but in the context of unenforceability, paragraph 7, the unpleaded arguments, paragraphs 32 to 33, argue they're all unenforceable, and that they'll set out in detail arguments as to why this is the case in due course. 8, it's respectively submitted that this constitutes another denial of liability, which will be disputed, must be fully pleaded, will require disclosure, and if successful will render any detailed assessment of costs entirely OTOs. And then if I can pick it up at paragraph 18, point being made that Mr. Flack's argument appears to be that CFAs are enforceable and as a consequence no fees payable at all. If his arguments that defendant repudiate a CFA 3 and no fees at all are payable are proven, then no assessment will be required. The arguments on liability to pay costs under CFA 3 must therefore be heard first and by a judge with the benefit of witness evidence and disclosure. And then that finishes off at paragraph 24 on the next page, seeking a transfer to the Chancery Division. The claimant's global skeleton, dated the 14th of June, in fact that does refer to the hearing being the 15th of June, is at tab 9, page 57. And the first part of it is concerned, we don't need to be bothered with it, with having the hearing in private. And then over the page on paragraph 9, on page 58, On proper analysis, little would appear to divide the parties at this stage. Both recognise that the trial of preliminary issues are appropriate and both seek directions to that end. The defendant appears to raise an obstacle to the logical order for determination of these preliminary issues by seeking to make play with the parties' differing stances on the question of which party was responsible for the determination of the retainer post-August. Determination is not relevant to the other issues identified by the parties. In any event, such an issue is not uncommon in proceedings such as these. Neither party seeks to bring any wider claim against the other in respect of termination of contractual relations between the parties. So that's a reference to the fact that the point being made by the solicitors was you're seeking to have, as part of these proceedings, a determination of the question of termination of the agreements. That should be dealt with in part 7, and they're saying here, no, it can be dealt with in the cost proceedings. And then in 13, the issues in the current dispute falling within scopes of fall within the scope of the court's expertise. This is the right venue for their adjudication, and no attempt to expand or confuse these issues on the part of the defendant can or should distract from this. Accordingly, it's respectfully suggested that the court should give directions designed to permit the speedy and efficient resolution of preliminary issues. And then over the page, the scope of the Part 8 proceedings, the enforceability of the CFAs, and reasonableness and appropriate level of each success fee, bearing in mind success fees is only part of the sums being claimed. And in order to facilitate determination of these preliminary issues, the court is respectfully requested to give directions. And it's that which leads to the hearing on the 15th of June, which is which counsel appear, and then the order made the next day at tab 10, page 60, of the determination of the matters as preliminary issues. At this stage, it was for a hearing that was going to be on the 23rd of November 16 for one full day. And it's the issues that we see in 1A and 1B. So this isn't the master going off on her frolic of her own. She's taken the material before her, which identifies issues going to whether there's any liability at all, as identified in the material before her, with the claimant's GHC's own note saying there's not much between the parties, other than whether it stays here or goes to the Chancery Division. And then this order is made.
But I don't understand this, your submission on this, because if you go to page 59, at any rate, what the claimant was suggesting was that the preliminary issues should include, the enforceability of the CFAs.
Yes.
In the light of that, the master made a different order for the preliminary issue, whether the CFAs entered into between the claimant and the defendant were valid, which is different.
Well, the point that was being raised in relation to validity was this enforceability issue concerning Section 58 of the Courts and Legal Services Act, because it was being said that there is no liability because the requirements of Section 58 have not been complied with. And indeed, that forms part of the matters which are pleaded in the particulars of claim, which are are pleadings which are directed to be made for the purposes of the preliminary issues, pursuant to paragraph 2 of the Master's order. So if we move on from there to the actual pleading itself,
This is the pleading
So-
produced pursuant to paragraphs 2 and 3 of the.
yes, correct. And what we have is the pleading with all its colours as existed at the date of the preliminary issues hearing. This is at tab 13 of the supplemental bundle at page 93. And one can see that the particulars of claim were both amended and re-amended. We turn to the page 143 in the bundle. We can see the amendments in red.
Mine are all in black and white.
Sorry?
Mine are all in black and white.
Yes, mine, but
Oh.
don't think it
It
matters.
doesn't matter at all.
Okay, well, if you can take it from me that if we go to page 143, the crossings out are in red at the bottom where it says dated this 27th day of July 16, and then it becomes 17. So we've got an amended pleading which is in 2017, which appears to be after the order of Master James, and then further re-amendments subsequent to that. And if I ignore the green, what in my copy are the green amendments, and just look at the red, which is the position which I submit is after the March 17 hearing before Master James, and just see what the pleading is. First of all, in relation to,
Sorry, and you're saying these amendments, rather than re-amendments, are after the hearing before Master James in
Yes.
March 2007?
because there was a hearing there to deal with amendments to the particulars of claim and a hearing to do with striking out parts of the particulars of claim. And therefore, what I suggest is that the red amendments must be after that, the position after that hearing. And what one can see from, first of all, in relation to termination, well, let me start with paragraph 1, the introductory summary. The claimant denies that the conditional agreements that it entered into with the defendants are either valid or enforceable. So we get both epithets used, valid and validity or enforceability, as a result of the CFA's failing to comply with the provisions of the governing legislation and the defendant's professional obligations. And then alternatively, if CFA 2 and CFA 3 are enforceable, so that is the alternative to what was the first sentence of paragraph 1, the defendant's termination of them was wrongful, and the defendant is not entitled to recover any remuneration in respect of them, or alternatively in respect of CFA 3, and the defendant is only entitled to its basic charges plus disbursement. So the position that was being taken at the
I'm not quite sure
preliminary
where all this is
issues.
going, Mr. Georgie. I mean, if you want to persuade us that objection 1 had not been formulated at this time, that's right, it hadn't been.
I'm not seeking to persuade you of that. What I'm seeking to persuade you of is that objection 1 was extremely closely connected with the challenges to on liability that were being advanced in this preliminary issue stage. That's the point I'm trying to make. And one can see that's taken, the point about termination is then taken forward at page 98, paragraphs 19 and 20.
Sorry, where are we? That's right, my fault. I just lost track.
98, page
Thank you.
98,
Thank you.
paragraphs 19 and 20. There is then a very lengthy section of the pleading starting at page 132. Under the heading post 28 July 15 conduct and termination of the retainer, CFA 3. And that runs all the way through to page 141 with the conclusion, paragraph 141. That it's denied that the defendant was entitled to determine CFA 3. First of all, on the basis it was invalid, enforceable. Secondly, it was an entire contract. And neither the claim nor the assessment had been completed. And over the page, there was no good reason for termination, and such termination was contrary to the relevant provisions of CFA 3. Clause 14.3, since the claimant was not, nor has it ever been in breach of its responsibilities. So the primary position taken then is that even if the agreement was compliant with, was enforceable, it was wrongfully terminated, and that's at paragraph 142. And then at 143, alternatively, even if the claimant was in repudiatory breach of CFA 3, which is denied, clause 14.3 provides that the defendant would only be entitled to its fees for the work done to the termination date, and disbursement does not provide for any entitlement to success fees. Then they say we weren't entitled to terminate under any other provision. And then over the page, any repudiatory breach at 145 would not have caused the automatic termination, but would have given the right to elect, to affirm or accept, and the defendant gave its notice of election to terminate. And then in terms of the relief sought, CFAs in each of them are unenforceable, invalid. 2 are found unenforceable, they're wrongfully terminated. And then 146.3, if enforceable and not wrongfully terminated, defendant is to pay the claimant the sums due, and that's in respect of CFA 1, followed by basic charges, disbursements and success fee. And then 146.3, if CFA 3 was found to be enforceable and defendants found not to have terminated wrongfully, such termination was pursuant to clause 14.3 and it's entitled to its basic charges. So we have quite clearly here the offences on liability which go to the termination of the agreement, in addition to other offences on liability, which the court was being asked to determine. The objection now advanced, which is effectively none of this matters, because whether or not it was lawfully terminated, or whether or not it was unlawfully terminated, they're still not entitled to any money. Not only is that not consistent with the way it's put in this pleading, it is a point which, if it was going to advance, would really have been the first thing the court would have needed to consider. Because why would the court otherwise have to embark, if the position was that, regardless of validity of termination, there was no entitlement to payment, consequent on termination, common law, then that should have been the first issue that the court would have determined as part of this preliminary issue.
Maybe the first, but it wouldn't necessarily be the only, because all these other things would have to be dealt with as well, just in case the conclusion on the first issue is overturned.
Yes. Depending on how the court would want to approach it, because if you've got an issue which is very self-contained, isn't going to require a lengthy trial with witnesses, effectively a point of law, then one approach might have been to have that determined first and see where that got to before engaging in the time and expense of hearings a trial as to the lawfulness of termination.
Forgive me for being so slow, but how is that relevant to the issue of abuse?
Because we say that this is an issue or defence which could and should have been raised at the preliminary issue stage, because the court was concerned at the preliminary issue stage and was making a decision as to, in broad terms, the impact of termination on liability. That's what the court was concerned with. This was very closely tied, if not effectively part of, the issue which the court was looking at. And instead, for reasons which have never been explained, objection 1 was never raised. We go through the whole process of the trial in front of Master James, the adverse findings on termination, appealing those findings in front of Mr. Justice Trower, and succeeding in finding that in him setting aside the finding of unlawful termination and finding lawful termination, and then we're suddenly faced with, oh, but it doesn't matter anyway, because even then there's no liability. I mean, how that could not, I ask rhetorically, not be fall square within the authorities in relation to what constitutes abuse. In my submission, it obviously is.
Well, a rhetorical answer might be that these parties are so litigious anyway that all these issues were going to have to be decided and probably be appealed, and second appeals made in any event, so it really doesn't make all that much difference. It's a tendentious way of putting it, but there doesn't seem to have been any loss of appetite for further litigation between these parties.
But if the issue had been raised at the preliminary issue stage and dealt with, then
if this is the proposition, but if this had been raised at the early stage and Rosenblatt had lost, then we would all have packed up their tents and gone home. I would find that
No, I'm not.
difficult
I'm not suggesting that, but then the challenges to the decisions that were made would be made in the knowledge that unlawfulness of termination or lawfulness of termination would not necessarily get us there. We would have this first argument to deal with. Well, I mean, we're effectively, I appreciate that you're not entirely with me, let me put it this way, on this being a decision of liability at the preliminary issue stage. And I have sought to persuade you that at the very least, the intention was to deal with the issues of liability that had been identified by the parties on the footing that if liability was found against my clients, then there would be no purpose in proceeding to a detailed assessment. But in circumstances where the termination of the agreement is the defence that is being advanced on liability as to why there is no liability. In my submission, it must be incumbent on the party seeking to advance the defence of liability arising from termination to put its case as to termination being a complete answer, not just for unlawful termination, but for lawful termination. To avoid all the delay and expense that would be caused by raising it late, but also to avoid my clients being harassed with a yet further point arising out of termination, when quite obviously in my submission, the parties were proceeding on the footing that if termination was lawful, that something was due. I mean, the position that was being taken by the by GHC in the pleading was not was quite simply that if there was a lawful termination, it's 14.3 that sets the amount due. There was no suggestion that it would be nothing at all.
You weren't claiming under 14.3?
No, we weren't. But well, I've taken you to the pleading, and the way that they were putting it was, if it turns out to be lawful, didn't say if it turns out to be lawful.
If it turns out to be lawful under 14.3, then ...
Yes.
That's how you put it. Or
The
that's
way
how
they
you
put it was, if
characterise
it was found to be enforceable and defendant is found not to have terminated it wrongfully, such termination was pursuant to 14.3, and accordingly they're entitled to basic charges.
That was paragraph.
1464.
But you're not claiming to have terminated it under 14.3.
No.
You are claiming, well, I'm actually not entirely sure what you are claiming. You're not claiming that there should be a line-by-line assessment of the bill, are you? You're saying you have a claim for damages, or you have a quantum merit claim.
Yeah, I am saying that I have a claim for quantum merit.
Yeah. And
would
your
involve
claim
a
for
valuation
your
of
claim for quantum merit is expressly denied in paragraph 142 of this pleading. Right, it's true that it says that that's because of a wrongful termination, but nonetheless, the quantum merit claim is put in issue.
Yes, but sorry, but they were making the point. I mean, I think that actually reinforces my point. The point that they were advancing here was it's our non-entitlement to recovery, whether that be basic charges or otherwise, including a quantum merit basis, all arises as a result of wrongful termination of the agreement. But in fact, the defence they're wanting to put by way of objection 1 is...
Yes, I follow. Even if it was lawful,
Yes.
you still not.
I mean, maybe I could...
Can I just interrupt you for a moment? I'm a bit concerned about the time. We're not a long way through your structure for this first appeal, let alone having got on to the second appeal. How are we doing for time?
well, look, what I'm proposing to do is I'll try and complete this section as quickly as I can. I mean, in a sense, I have made most of the points I want to make anyway, but I do want to take you briefly to orgy on the authorities, and the other case really rises on my friend's Respondents notice, where he's saying even if there is an abuse, you should there are other remedies available. So maybe I won't take time up with that, and then I will move on, certainly by no later than 2 o'clock, to the second half of my submissions on quantum merit. I may...
So, Mr. Cordier, you're going to cover why permission should be given on the second
Yes.
appeal.
Yes. So Just give me a moment. In relation to the law on Henderson abuse, in the judgment of Mr. Justice Marcus Smith at that's core bundle 1, page tab 8. Let's give it a moment. Paragraph 17 on page 92. He sets out in that paragraph the principle, he says it's trite, that a Henderson v. Henderson type of abuse arises where for no good reason a party to proceedings fails to avail themselves of an opportunity bringing before a court, a competent jurisdiction, an issue for determination, which then remains unresolved until a later point in time, in circumstances where the later resolution of the point is causative of procedural waste and inefficiency, with no sufficient countervailing justification for dealing with the point late in terms of procedural fairness or due process.
Maybe trite, but it's not a formulation I've ever come across before.
Nor have I. You say it's correct, do you?
Well, I'm going to take you to orgy, and then let me make my submissions on the back of that. So if we go to the decision in orgy, which we'll find in the authorities bundle at tab 20. I've got my authorities. Yes, it's volume 2. I don't know if you've got it in 3 volumes or right. It's tab 20. It may be in volume 2.
Yes. Volume 2, tab 20, yep.
At the page, so in terms of the judgments, we've got Lord Justice Coulson delivering the main judgments. We have Lord Justice Nuji agreeing with that judgment and adding a few words on the scope of the Henderson principle. And then my Lord Justice Stuart-Smith agrees with both judgments. So in terms of the facts, we've got perhaps just paragraphs 2 and 3 on the left-hand side, page 552 of the bundle. Just invite you to glance over that. And then if I can pick it up in Lord Justice Coulson's judgment at page 560. Paragraph 41, there were 2 issues in the appeal. The first concerned Henderson and Henderson, and then the second aspect concerned a separate basis for seeking to strike out as an abusive process as a consequence of the way that a hearing on the amendment or re-amendment of the particulars of claim had taken place before District Judge Stewart. And in relation to Henderson and Henderson, we've got the citations at 44 and 45, the well-known citations from Henderson and Johnson and Gore Wood, and then at 46, both Henderson and Johnson are primarily concerned with the party seeking to raise in subsequent proceedings an issue which has either already been decided in earlier proceedings or which could and should have been raised in those earlier proceedings. Not necessarily for there to be two different sets of proceedings. A single set of proceedings involve a binding termination at an earlier stage, then the rule in Henderson may apply to the subsequent stages of the same litigation. And then at 47, follows that rule in Henderson can apply not only to one set of proceedings, but to earlier interlocutory decisions in those proceedings. Crucial to remember, whenever it arises, the rule requires a previous determination by the court. And then I'll just give a moment.
So as Lord Justice Coulson quotes from Lord Hobhouse, who says it will be a rare case where the litigation of an issue which has not previously been decided will amount to an abuse.
Yes.
What is the issue here which you say
There needs to have
has
been-
been decided?
There needs to have been a previous determination by the court. In this case, the previous determination by the court was in relation to the preliminary issues, at which point we say, this defence should have been raised. That is the relevant determination, including its determination
Well,
on the termination point.
Global Energy say you, Rosenblatt, wrongfully terminated CFA 3.
Yeah.
And as a consequence, you're not entitled to have any money. You, Rosenblatt, say, no, we lawfully terminated CFA 3.
Yeah.
And the court found in your favour that you did. Global Energy say, well, all right, let us then consider the consequences of the court's finding that you, Rosenblatt, lawfully terminated CFA 3. That issue has not been decided anywhere, has it?
No.
So how does that square
Because I think that comes
with what Lord Hobhouse said?
Well, I mean, if it does square with what is being said here, because what we are concerned with is whether there has been a previous determination by the court. Obviously, it has to be a relevant previous determination by the court. It doesn't require that the court needs to have determined the very issue which they now want to raise. Otherwise, we'd never get into a situation of abuse working at all. The point that is being made here in my submission is that you need a previous determination by the court. In the case of a previous determination by the court of an issue with which should have been at which this further line of defence should have been raised.
You say there was a decision on preliminary issues as drafted,
Correct.
and they included issues which were akin to this one, and that therefore it should have been raised on that occasion.
Yes,
That's the
that's
beginning
it.
and the end of it.
In contrast to the position in Orgy, where there had been no determination of any sort by the court in relation to any substantive issue. I mean, the way I would put it is not that the issue that was being raised was the court's determination was there a wrongful termination and what is its consequence? It's rather that they were alleging that they had no liability as a result of termination, and the detail of why they said they had no liability as a result of termination was that it was a wrongful termination, and in the alternative, that it was a termination which was subject to 14.3. They weren't ventilating an issue in relation to termination and the lawfulness of termination for the fun of it. They were advancing such an issue because they were relying on the termination that took place as disentitling my clients to any sums in respect of their retainer. And therefore, when one asks the question as to whether the principle arises, just picking up the last sentence of paragraph 447, Lord Justice Newdy reiterated in Wilson and McNamara by reference to Henderson and Henderson that the principle does not arise if there has not been a previous adjudication by the court. And in this case, there clearly has been a previous adjudication by the court. The other passage I wanted to pick up is in Lord Justice Nudi's judgment. If I can ask you to turn to page 568. Paragraph 81. He refers to Wilson, McNamara, and where he said that Lord Sumption considered Henderson's treated as one of a number of disparate principles grouped together under the portmanteau term of res judicata. As this label, the thing adjudicated on, indicates, the essence of the principle, like other aspects of res judicata, is once that a particular matter has been determined by a court, that may preclude a party from having a second go, or to put it in colloquial terms, a litigant is entitled to their day in court, but once they have had it, it's not generally entitled to a second bite of the cherry. And then he deals with the 82 with prosecuting a claim that may preclude bringing a second action raising the same cause of action. And then over the page, still in 82, 4 lines down, the underlying justification for all of these principles is similar. Once a claim has been determined, that subject to appeal should be that, and the parties should not be troubled of having to defend themselves twice. The effect of the Henderson principle is that this is capable of applying not only where a litigant seeks to run exactly the same point, but also a different one, so long as the new point really ought to be taken, if it was to be taken at all the first time round. And I do rely on that analysis as being both a correct analysis of the Henderson principle and its application on the facts of this case.
What do you say about the first 2 sentences of paragraph 84?
Well, I still say that applies in this case, because
What are Global Energy trying to reopen that has already been decided?
the question of no liability arising from termination of this agreement. That's what they're trying to reopen. If you take it too narrowly, then you'll virtually never get a case where you're going to fall within abuse. You've got to look at the substance of what was going on before the Master James in terms of defence and liability. And the substance of what was going on was that they were arguing that because of the termination of the agreement, there was no liability. And they put that on the footing of unlawful termination. It doesn't detract from the fact that this was all arising from the termination of the agreement.
Yeah.
Yeah, and then just to pick up paragraph 83, at the very last sentence, whether in any particular case the second claim is abusive depends on whether or not, whether it not only could but should have been brought first time round, and that requires a broad merits-based judgment, as explained by Lord Bingham in Johnson and Gore Wood. And that, just to remind you, I'm sure you know, that broad merits-based judgment is, that passage appears at the top of page 561, just before we get to paragraph 46. It's very well known, much quoted, taking account of the public and private interests involved, taking account of all the facts of the case and focusing attention on the crucial question whether a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. And we say that applying that approach in this case, first of all, it could have been brought. Secondly, it should have been brought because it was, even if you're not with me on this being for the determination of issues of liability, it clearly was dealing with defences on liability arising from termination, and this was very closely part of that. And three, having regard to a broad merits-based approach and taking into account the inevitable additional cost, delay and unfairness we submit in having this point surfacing after we've gone through a whole preliminary issues hearing and appeal, is unfair to my clients, and taking those factors together, there is an abusive process, and the judge should have so found, and that the judge went wrong because he considered, first of all, that the master had gone on a frolic of her own, which he hadn't. Secondly, he considered that it would because she'd gone on a frolic of her own, she committed a gross error of procedure because she should have had pleadings identifying what the defences of liability were, when in fact those defences had been identified in front of us, so it was unnecessary. Thirdly, that he found that it would have been improper to try and raise this issue at the preliminary issues stage because the court orders need to be obeyed, and that just simply must be wrong. There is no obligation not to refrain from telling the court that there is a further issue of liability that needs to be determined. And indeed, for the reasons I've submitted, they should have done just that. So for those reasons, we submit that the judge erred in his decision, and that in determining that certain steps should not have been taken by GHC in relation to the order, in relation to the preliminary issues order by raising an issue, and in saying that the judge should have taken the approach of having pleadings, that he erred in as a matter of principle and practice. And that brings me to the principles for an application of the grounds for permission. In relation to that, it is common ground that under 52.7 of the CPR, we've either got to show real prospect of success and raising a point of principle or practice that has not been established at this level of court, or that there is other compelling reasons. So far as the authorities are concerned on that, the principal authority is uphill v BRB, And there was then a further judgment of this court in Congo that we have referred to in our skeleton argument. If I can take you briefly to those cases, so far as uphill is concerned, that is to be.
So before you do so that I've got it absolutely clear in my head, you say there are important points of principle and practice. Please, will you just encapsulate them for me?
Yes, can I do that by reference to the grounds of appeal so that
Yes.
you can actually see it? So if you go to tab 2 of Core Bundle 1, so at in relation to the grounds which are set out under the heading major procedural error on the part of the court acting of its own motion, at 6 we say the learned judge held that the court should have obliged the parties to set out all their contentions by way of pleadings before directing preliminary issues. We say he was wrong in principle, no necessity within costs assessment to require parties to go to time and expense of pleading out their cases on liability before making case management directions. Judge is perfectly entitled to take a less formalistic route to identification.
Your essential point on this ground is the judge got the facts wrong.
Yes.
Well, that's not a second appeals point.
Well, because he got the facts wrong, he then criticised the judge, but said that what the judge should have done, instead of going on a frolic of her own, was to have pleadings. And that is the point we then raise in 7, namely whether in pursuance of the practice of the court on cost assessments to determine first liability, it's incumbent on the court to direct service of pleadings on liability before giving directions to determine liability. So in answer to my lady Justice Asplin's question, that's the first one. So far as the second ground is concerned, improper to shoehorn.
So what you're just taking me back to the paragraphs that you set out
Yes.
in those grounds. Okay.
Yes. And then a paragraph, the second set of the second ground starts at the bottom of page 14 onto the next page. Paragraph 9, judge urging principle in holding, you see what's set out there, and then paragraph 10 raises an important point of principle, and then you can see what's set out there. And then,
Again, it's ground.
yeah, and then similarly at 12. So those are the point of principle grounds, but we also say that there are other compelling reasons for permitting and allowing this appeal. And this section identifies the errors the judge made, including the error concerning the master going on a frolic of her own, and the matters we rely on as giving compelling reasons for granting permission to appeal, paragraph 23, are first and foremost that the appeal has a very high prospect of success, and that this isn't a case where the errors of the learned judge are due to any failing on the part of Rosenblatt. And then we also rely as further factors on the fact that this appeal is effectively a challenge on the decision, on the reasons advanced for the first time in the judge's judgment, in Justice Marcus Smith's judgment, because it was on the respondent's notice. He actually had
Yeah.
found that the senior cost judge had got it wrong. And then the fact that his decisions founded in large part on serious criticism of the litigation by Master James. And that just brings me then probably to just take you on the other compelling reason head to what's said in the authorities about other compelling reason. If I can pick that up for the short adjournment, first of all.
I'm sorry, I put you off because you were going to take, I think, us first to uphill, weren't you?
That's what I'm taking
Yeah.
you to,
Go.
exactly. At tab 7 of the authorities bundle, and he deals with in the judgment of the court of Lord Justice Dyson, as he then was. We have at page 143 started the discussion on some other compelling reason, and 21, paragraph 21 refers to the editors of the Brown Book, that it was inserted to provide an ultimate safety valve, allow the Court of Appeal to entertain an appeal notwithstanding the point was a one-off of no general import. For example, the decision sought to be appealed was so grossly erroneous or unfair that it would be an affront to justice to allow it to stand. And then over the page, paragraph 23, mindful of the need to interpret the relevant CPR provision as it then was in 2513 to give effect to the overriding objective. In view of the apparent uncertainty as to the stringency of tests, elucidate the phrase follows been approved by the Master of the Rolls, etc. And then at 24:1, a good starting point will almost always be a consideration of the prospects of success. It's unlikely that the court will find that there is a compelling reason to give permission for a second appeal unless it forms the view that the prospects of success are very high. That would usually be a necessary requirement, although, as we shall explain, it may not be sufficient to justify the grant of permission to appeal. The necessary condition will be satisfied where it's clear that the judge on the first appeal made a decision which is perverse or otherwise plainly wrong. It may be clear that the decision is wrong as it's inconsistent with the authority of a higher court, which demonstrates the decision was wrong, subject to what we say below. Anything less than very good prospects on an appeal would rarely suffice. In view of the exceptional nature of the jurisdiction, it's important not to assimilate criteria for giving permission, which is real prospect of success, with those which apply in relation to second appeals. And then he says this at 2, although the necessary conditions which we have mentioned at 1 is satisfied, the fact that prospects of success are very high will not necessarily be sufficient to provide a compelling reason for giving permission. An examination of all the circumstances of the case.
We can read this to ourselves, Mr.
Okay, I just wanted to emphasise that he deals
Yeah.
with where that may not be the case, which is
1, 2, and 3.
yes. And the law, we submit that for the reasons that I've already addressed you on, this is an appeal which has a very high prospect of success. It isn't a case where we're seeking to advance reliance on an authority which wasn't before the judge, and the judge has gone wrong as a result of us not putting it before him. And we do pray and aid the other factors that I took you to in our grounds of appeal as further additional factors of weight as to why there are other compelling reasons in this case. If you're with me on that, then and permission is granted, then the appeal, which would then also be allowed for the same reasons I've given.
Right,
Got there.
good, well done. So those are your submissions on the
Yes.
application for permission to appeal. And
Yes.
good, thank you very much. 2 o'clock.